Hello, good morning, and welcome to the first of three sessions in 3PB's Judicial Review in Education series. Part one today is Section 42 of the Children and Families Act, and I'm joined by my colleague Matthew Wyard, who is also in the education team. I'm Alistair Coverley. I'm an education, public law and discrimination barrister. And my colleague Matthew is a public regulatory and human rights barrister who also specialises in court of protection work and education work. Both of us are ranked in Chambers of Partners for education, and Matthew is also ranked for public law. So today's talk will be approximately 45 minutes of us talking, and we then have the opportunity for questions and answers afterwards. Which hopefully will be your opportunity to ask questions. It might be that there are questions that we can answer along the way, but we will scoop up any kind of remaining questions at the end as well. And again, if there's anything you want to ask us about after today via email, we're very happy to talk to you. There may be things that we don't have time to cover today. So our approach in this session is to give you both sides of the story when it comes to a Section 42 challenge. So many of you are here from claimant firms, many of you are here from either local authorities or judicial respondent firms and or other sort of organisations. And really what we're here for is to give you both sides so that you can see firstly where one side is coming from, but then also see what are the sorts of things that the side that you're on might really need to think about when you are trying to successfully deal with a Section 42 challenge or try to win a Section 42 challenge. So these tips and tricks and case law overview comes from our experience in being instructed in these cases. 3PB is routinely on both sides of these cases, which does help us in Chambers to be able to manage these kinds of claims. So we're going to go through firstly the claimant approach to pre-issue. So what are we doing before the claimant decides that they're ready to issue a claim, litigation, whether or not they are ready to do a letter before action. Then what the defendant does when it responds to that letter before action, what happens in the background there. Then we're going to look at the claimant's approach to litigating the claim, and then the defendant's approach to defending the claim. And then, as I said, the opportunity to ask questions. So we hope to give you some tactical, practical and legal tips in this seminar. And so we're going to start now with the pre-action stage with Matthew.
Thanks, Alice. Morning, everyone. Thank you for coming along. As Alice has said, we're each going to take a side. So you'll see for the whole talk, I'm going to deal with things from a claimant perspective. Alice is going to deal with things from a defendant's perspective. And the most straightforward way we figured to do this was with a case study. And that's what you can see on your slides now. So the case study that we're going to use concerns JH. JH is, as you can see from the slide, a 17-year-old, so a young person under the Children and Families Act, with an EHC plan that's maintained by South Buckwold District Council. The EHC plan provides, for the purposes of this talk, for two things. Firstly, that JH receives full-time one-to-one from a dedicated TA. And secondly, 1 hour of speech and language therapy per week. And it's not on the slide, but for the purpose of this talk, assume that when we say that, we're referring to direct speech and language therapy provided by a speech and language therapist. And as a claimant representative, JH comes to you and says that they are concerned that they're not receiving their provision. So they're not receiving their dedicated TA time or their 1 hour of SALT per week. And for hopefully most people watching the webinar, the first thing that should spring to mind is helpfully the topic of this talk, enforcing JH's EHC plan through a Section 42 judicial review challenge. So with that being said, let's turn to consider the law of Section 42 claims. Thanks, Alice. So Section 42 of the Children and Families Act says effectively For our purposes today, two things. Section 42, subparagraph 1 and subsection 2. Subsection 1 says that the section as a whole applies where a local authority maintains an EHC plan for a child or young person. And that really is the threshold to engage Section 42. For it to be engaged, a local authority needs to maintain an EHC plan for a child or young person. Section 42, subsection 2, the local authority must secure the specified special educational provision for the child or young person. So read together, it's a relatively straightforward statutory duty. A local authority that maintains an EHC plan for a child or young person, where they do, must secure the SEP for the child or young person. What do we mean by special educational provision? Well, it's that provision that's outlined in section F of the EHC plan. Relatively, at this point, a straightforward statutory duty. It has, however, been subject to a number of authorities, but not the first authority that we're going to turn to, which is N and North Tyneside Borough Council. N and North Tyneside Borough Council, as most of you will be able to tell from the date of the decision, was heard under the Children and Families Act regime. It was heard under the Section 300s of the Education Act 1996. And at paragraph 17 of that decision, it considered the obligations under that regime. And there was effectively a mirror provision of Section 42 under the 1996 Education Act, and described it as a mandatory duty with no best endeavours defence. Again, as with the actual duty itself, relatively straightforward. You can't defend it on the basis that you're doing the best that you can to secure special educational provision. The point is you have to secure that provision. Now, the principle from North Tyneside was brought into force under the new regime. Some people say it's by BA and Nottinghamshire County Council. I tend not to use that one. I use that for another purpose that we'll come on to. I say the real key authority is ZK in the London Borough of Redbridge, and that's because that, unlike BA in Nottinghamshire, is a Court of Appeal authority. And at paragraph 13, it looks at North Tyneside and brings in the ratio of North Tyneside under the new regime. Now, BA in Nottinghamshire is relevant to these cases. It's relevant when you're looking at something we'll look at slightly later, which is a defendant trying to render your claim academic, because in BA in Nottinghamshire, the court looked at a situation where the defendant local authority had tried to render a judicial review academic and reiterated the principle of North Tyneside and effectively said, you're not doing enough. You have to implement the entire plan. Three authorities at the bottom of the slide that you don't often see referred to under Section 42 claims, but they are worth bearing in mind generally. E and Rotherham from 2002 effectively supports the proposition that a local authority cannot amend an EHC plan unilaterally by choosing what part of an EHC plan to implement. If it did, it would frustrate the statutory annual review process. The key reason being that if you have an annual review, that then gives you a right to appeal if you disagree with something that's done. So a local authority can't get around having to hold an annual review by just choosing what to implement. It would fly in the face of the Section 42 duty, but also the requirement to give an affected appellant the right to appeal. Gloucestershire County Council and EH is an important one to remember when you're representing someone who is above statutory school age, compulsory school age, because paragraph 50, subsection F of that decision effectively says that being above compulsory school age makes no difference. A local authority would still need to implement the entire EHC plan. Lastly, Imam and Croydon we'll come back to when we deal with remedy. That is not an education case. It's a very important general public law case that has an impact on the education challenges. So looking at that as a whole, what can we take away from it? straightforward statutory duty. The law is very helpful to claimants because there's no best endeavours defence. In reality, nothing else will do apart from full implementation of Section F of an EHC plan. And there have been attempts to move outside the scope of that, but ultimately the law always comes back to the mandatory duty under Section 42 of the Act. It's a simple, straightforward obligation, which is of real benefit to claimants bringing judicial review challenges. Alice, if we can move on to the next slide, please. My best Boris Johnson impression. So that's the substantive law for Section 42. What you're trying to do is obtain permission to bring a judicial review claim to try and enforce JH's EHC plan. So you need to have some idea of the law and the practice and procedure of the admin court. And the first point that's helpful to know is that the threshold to get permission is low. It's arguability. Do you have an arguable breach of statutory duty? And where you have an arguable breach of statutory duty, in theory, you should get permission to bring your claim. So we've got a straightforward statutory duty and a low level for permission. The case generally, because of the strict statutory regime and the interpretation of the duty under Section 42, means that on a purely legal basis, these cases are very difficult to defend on the law. They're also, as we'll come on to see, often tricky to defend on the facts. From a financial perspective, they're interesting because for those of you who don't practice judicial review as much as some, you may not be aware of some of the funny intricacies of how the cases are funded. The vast majority of claimants will bring a Section 42 challenge with the benefit of legal aid in the child or young person's name. Where you do bring a case with the benefit of legal aid, if you lose your judicial review challenge, then as the lawyer's bringing the claim, you still get paid by the legal aid agency, and the defendant cannot recover its costs, usually from the claimant. And there are very real exceptions to that, but they are rarely ever run. In effect, the claimant would need to win the lottery. If you succeed in your judicial review challenge, despite having brought it with the benefit of legal aid, you are still able to get a cost award and you can recover your cost at your usual commercial or private rate. The point being that there's a very real financial risk to the defendant if they go all the way to trial, because whichever way the case goes, win or lose, the defendant is not going to recover its legal fees. And if you are successful as a claimant, you're going to be able to recover typically quite a high level of legal fees. So that's obviously never going to be the be-all and end-all of whether or not you bring a claim, but it is a relevant factor for a claimant representative to bear in mind when they think about the case from the defendant's perspective and the level of risk that the defendant takes if it tries to defend your case. And lastly then, at the pre-action stage, once you've considered all of those options, you also want to consider about the alternative heads of challenge you can run alongside a Section 42 claim. Now, these won't be relevant in every case. There are some cases that you issue and you run it as a straightforward Section 42 challenge. It's the only ground of challenge that you bring. But equally, there are some circumstances where you can elaborate on your grounds. And what kind of circumstances am I talking about? Well, if the claimant is of compulsory school age, but they are out of school, then you might think that you could also run a Section 19 judicial review challenge in the alternative. So that's a challenge run under Section 19 of the Education Act 1996. If you want to hear more about what a Section 19 challenge is, then come along to the second webinar that we're doing in the Education Judicial Review series, because two of my colleagues will be teaching you all about that. Equally, as I had in a case recently, if the local authority is not only failing to secure all of the provision within an EHC plan, but they've also taken the decision to cease to maintain an EHC plan and are not securing the provision post an appeal outcome, you can think about tacking on a Regulation 45 challenge to your claim as well. So that's an alternative ground of claim that effectively says they're not maintaining the EHC plan following a cessation decision pending the outcome of an appeal. So the point being that there are alternatives you consider, and you should be considering them and applying them to the facts of your individual cases. And Alice, if we can change the slide, please. That's the legal framework. That is some practical considerations that you need to have when you're representing a claimant. What then about case analysis? Well, let's turn back to JH. The first question, we know this from section 42(1) of the Children and Families Act, is whether someone has an EHC plan and whether it's maintained. And we can see from JH's case that he does or she does have an EHC plan and it's maintained by South Buckwold District Council. So that's a tick in the box. You've met the threshold at section 42(1). The next question is, what does the EHC plan actually say? Often when you're running a first tier tribunal appeal, the point that is mentioned time and time again is that the provision within section F of an EHC plan must be so specific and quantifiable as to leave no room for doubt as to what has to be provided. Why is that? Well, it's for when you want to enforce it. Because if the provision that you're trying to enforce is not specific enough to be properly understood, then it's very difficult to persuade a High Court judge that you've got anything capable of enforcing. So once you've double checked, and do double check, that the person you're representing has an EHC plan, double check what they are actually entitled to under the EHC plan. Give you a practical example. I had a conference on Monday evening where my client was suggesting that a meeting, a particular multidisciplinary team meeting that was meant to be being held termly, wasn't happening. When I drilled down to why they believed it wasn't happening, their response was, well, because the parents are meant to be allowed to attend and I haven't been invited to a meeting. Well, when you read their child's EHC plan, nowhere within it did it say that the parent had to attend the multidisciplinary team meeting. So it was trying to work out exactly what was wanted and what was enforceable. You then need to look at what your client's position is. And usually the prima facie factual position will be, I've got an EHC plan, I'm entitled to this provision. Most of the time, the client will get it right as to what they're entitled to. And their position will be, I'm entitled to this provision, it's not being provided. And on the face of that, prima facie, they have a good case. But the next question is, what evidence is there to support their contention that they're not receiving provision? Because one of the tricky points about judicial review is that where there is a factual dispute, the tendency, and you can look at the admin court statistics to prove this, as well as some of the case law, is where there is a factual dispute between the claimant and defendant. Usually, the defendant's version of events will be preferred. So where your client is saying they're not getting provision, you want to try to create a situation where you've got as much supporting evidence as possible in respect of their proposition. Turning back to JH then, what could you look for? Well, if JH isn't getting full-time one-to-one, someone at the school should know. Most likely the SENCO. So perhaps your client wants to speak to the SENCO and get confirmation from the SENCO as to how often a one-to-one is visiting the school. Perhaps if the SENCO agrees with you and says that there's no one-to-one there, you want to get a witness statement or something in writing from the SENCO to support it. Perhaps you want to raise a complaint with the school. Similarly, with the speech and language therapy, if you've got a good relationship with a speech and language therapist, get evidence from them. You can't always get definitive evidence at the pre-action stage, but it's certainly worth trying. Lastly, then, you need to preempt what the defendant's response is going to be. And there are typically, in my experience, two potential ways to defend a claim. Alice will come on to deal with these in far more detail shortly, but they tend to be twofold. They try to render your claim academic. It's not an awful lot you can do about that at the pre-action stage. You just have to hang on. Or they will try to argue that implementing the EHC plan is impossible. You can try to get evidence to get around that. So if the response is likely to be, we have no speech and language therapists in our local authority area, or we've got so few and they're all so busy, we simply can't provide your 1 hour a week, there is nothing at all stopping you as a claimant representative making contact with a private speech and language therapist, getting their confirmation that they are willing and able to provide the provision as well as their costs for doing it. And if you send that to a local authority alongside your pre-action letter, that is helpful evidence. We can go to the next slide, please, Alice. So lastly then, once you've collated all your evidence, you've analysed your client's case, you've analysed the law, what do you need to do? Well, you need to send a local authority a pre-action protocol letter. I'm not going to go through in any detail now what that letter needs to include. The most straightforward way to do it is to follow the template that's within the pre-action protocol itself. But in a nutshell, it will set out the legal basis for the claim and your application to the facts of your case. If you've done the legwork and you've got your evidence in advance, provide it alongside your letter. It only strengthens your claim. And make sure that when you do send your pre-action letter, you make a real effort to particularise your ground of judicial review in that letter. As a hint, I've given you the general wording I use on the slide. So it's a breach of statutory duty pursuant to Section 42 of the Children and Families Act. Make sure you use the terminology of the Act. So make sure you use the phrase secure the specified special educational provision. Don't do as someone I know did recently and say the local authority is obliged to maintain the plan, because that led to a whole load of pre-action correspondence about what the specific duty was, because the local authority got confused with what was being said in the pre-action letter, potentially quite justifiably. But beyond that, the two key points are collate the evidence that you need before you start and get a pre-action letter out to the local authority, having reached a judgment that it's worth doing, having analysed the law, the facts of your case, and the defendant's appetite for financial risk. With that being said, you should have a pre-action letter that's sent out that will hopefully land on Alice's desk, or not hopefully, depending on who you are. Alice, over to you.
Okay, so what happens then when you receive a letter before action within the local authority? Now, first of all, that letter before action may not reach the legal team because the letter before action may be written by a parent who may not know that it ought to be sent in reality to the legal team. So it may take a little bit of time to get to the lawyers. So if for whatever reason you're on this call and you're not part of the legal team, be mindful that you need to get it under the nose of your legal team as soon as possible, if not within an hour, rather than after a few days. I've seen some delay when that has happened. Once that does happen, we want to be starting to put together conferences and teamwork mechanisms within the local authority. So we want meetings with the lawyer, but also with those who are responsible for that plan. So by that, I mean the caseworker. You may have different structures within your local authority. You may have a social worker. You may have somebody who's involved was involved in the tribunal proceedings if they were very recent. It's really important at this early stage, once you get that letter before action, to get your information sharing done and to try and work out what's happened, why it's happened, and how to fix it. Often I see that stage hasn't happened, and I'm at the point of drafting grounds of response when I have a few days to do it, and there's not enough time to find out why things have happened in the way that they have. Once you get that LBA, do that from them. It's really, really essential. And through doing that stage of investigating, communicating with each other, you start to work out what the problems are what the blockages are, if there are any, and piecing together a bit of a timeline about what's happened. So also, once you get that letter of action, if you're the legal team in this room, or you're an officer managing EHC plans and families of children with EHC plans, you want to be doing a line by line check of that letter before action. There's some letters before action going to be, if written by Matthew, going to be detailed and setting out factually what has happened. And in those cases, you want to be checking what it is exactly that is being alleged that has not been done, why it's not being done, and what it is that they are saying is cited from that EHCP that is not being done. As Matt says, you also then go back and check that EHCP and see whether or not it in fact matches what is being alleged that is not being done. It is often, not always, but often the case that there is a reframing of what is said in the EHCP compared to then what is then translated into the letter before action. So, for example, where you have seen a TA being cited as something that's not being supplied, it may be suggested in the letter before action that a full-time teaching assistant that needs to be there during an unstructured time and must be there before the start of the school day and after the end of the school day for 15 minutes. For example, that might be being what's presented. But actually, when you look at the detail in section F of the EHCP, it in fact suggests a much lower level of teaching assistants. And it's really important to look at and match up what's being alleged that isn't being done. And quite often, there is going to be a dispute about the level of support that that young person needs. Not always, but quite often you will see that. And this is something that may come up later when you're looking at how you defend the claim. So once we've done that, you are agreeing an action plan. There may be a need for some further conferences together, further teamwork within the local authority, but you want to agree some internal timeframes. You don't want to be waiting until the last minute to respond to that letter before action. Within a week, you want to know, okay, what's happening with that teaching assistant? Why don't we have a speech and language therapist in place? If there is a speech and language therapist in place, what's going on? This investigation stage is crucial. One problem that often comes up is about the role of a school or college in their implementation on the ground of what is featured within the EHCP. And just as a reminder, the duty to secure that provision is on the local authority, but there are plenty of times where the difficulty may come down to what's happening at the school level. So examples of reasons why things might be difficult at the school level may be because of funding blocks, maybe because of change of leadership at that school, maybe because of information sharing, maybe for some reason they have an old copy of an EHCP or weren't aware of tribunal proceedings, whatever that is. So it's really essential to make sure that we are communicating with the school or college. I'm not suggesting you necessarily send them the letter for action, of course, but finding out what it is that is going on. And if, in fact, it's factually correct that a teaching assistant is not in place, speech and language therapy is not in place, and so on. And then the other major difficulty that will be coming up for local authorities, in fact, probably the primary difficulty, is going to be, we don't have any teaching assistants, we don't have any therapists. We know this as practitioners who are acting for local authorities. We see this all the time. It is really tough when there is limited resources and funding that is being that is plaguing the system at the moment. We're really mindful of that. The courts are arguably mindful of that, but go back to what it says in IMA, where it's stated, in principle, if resources are inadequate to comply with the statutory duty, it is for the authority to use whatever powers it has to raise money, or for central government. And so really it's at this stage that if there is something that you are not securing, you have to fix it. And you fix it at this early stage, so that by the time you get to your letter of response, you can say it's what are you talking about? We've complied. The other major issue that comes up, in my experience, is where parents are, or there is a dispute about the level of need of that young person. And there may be some difficulties with agreements about who the therapist should be, who the TA should be, whether that person is properly trained. I see that quite often, where, for example, a speech and language therapist is available, but they don't have autism training, or they don't have demand avoidance training, or ARFID training, or whatever it is. That then means that they don't really quite yet fit into the definition of who's doing things within the Section F. Or it might be that parents are saying that they need additional levels of training, but it's not actually what it says in Section F. Now, at the heart of it, parents are wanting the best for their children, but it is often parents who will be finding things very difficult because of the time that they have taken to get the support in the first place for their child. They may have been through several years of tribunal proceedings, spent a huge amount of money on experts, and it can be greatly disappointing, to say the least, for those parents where they get to this point where they've spent all that time and effort and money on getting that provision in place, and then for it not to be being delivered. So you're going to get some serious upset at this point, and I really emphasise the need to bear that in mind from the local authority side when you're balancing against the fact that I know full well that you are saying we don't have these resources, but it's up to you as a local authority to make sure that you can actually say that there are none of those resources. It's often said that we just don't have any speech and language therapists, and this is why Matt will say you should, as a claimant, list speech and language therapists to contact those speech and language therapists, check their availability, showing that court, that claimant, that you have done everything in your power. And that leads me to find an overarching point here, which is about communicating and keeping the other side in the loop with your plans, with securing provision, if it is the case that you are not yet able to. So these are two of the major ways in which a local authority can successfully deal with a Section 42 challenge. The first is to say it's impossible to comply because of the circumstances making you're able to make it available, but circumstances mean that is thwarted. And there may be examples of obstruction or difficulty to comply with that you could raise, but it is pretty high threshold, I would say, to say that something is impossible to secure. And this is where, if you were able to demonstrate through your witness evidence, we have contacted 5 speech and language therapists or 50 speech and language therapists, whatever it is, compared depending on which sort of local authority you're in. You need to be able to demonstrate that. Of course, you may also be able to say it's academic, because actually we are complying with this, or we have always been complying with this. It's not even an academic claim, there's no claim. And by academic, it means that there's no remedy that the High Court can really give, because in terms of a mandatory order making the local authority secure that provision, because you would say, well, we sorted it. And so this is why I go back to my practical advice, which is sort it out so that you can render the claim academic. And there will also potentially be some useful arguments that you can make as a local authority about whether or not in reality there is a suitable alternative remedy available to the claimant. Now, that's not always the case, because of course the first tier tribunal is not able to deal with enforcement, but it might be that there is in reality a dispute about the appropriateness of the provision that is set out in Section F. So casting your mind back to that question about whether the TA's role does actually need to be expanded, rather than just at those more structured times. So one of the other things for a local authority to consider, depending on how necessary it is to do an emergency annual review and to get the parties together, the experts together in the room, to be able to update that EOC plan to make sure that it matches the needs at that moment. Make sure you've got school or college involved to try and improve the situation. And then local authorities may well be in a position to say, well, actually the remedy is more through the first tier tribunal. The obvious counter to that from the claimant side is, well, first tier tribunals are hearing sections B and F claims 12 months from their being lodged. Is it really a suitable alternative remedy available to parents at the moment? Is certainly something that as a claimant you would be saying no to. So just bear that in mind. It is often raised that the expertise of the first tribunal is more able to analyse what that child needs by contrast to the High Court, who will delegate that position of what is appropriate for that child to the local authority, and it is within their professional judgment, that local authority, on what they think is appropriate in terms of the provider of that provision, in terms of who they recruit and so on. It's not in the parents' control as such. So those are the two things to be thinking about. Then we're looking at issuing the proceedings, and once that's received the pre-action response, hopefully they'll go away, but they might not. So what happens next, Matt?
Thanks, Alice. Well, Alice is right. Perhaps we will go away. Hopefully, the reality as a claimant is what you want to achieve is you want your client to get the provision that they're entitled to and need. So if a local authority turns around and, I don't know, says, go away, you've got a suitable alternative remedy, Alice is obviously absolutely right. The first response is going to be, no, we don't. It's going to take us a year to get this heard. If you've issued an appeal, well, here's your case directions to prove it. What happens more often at the pre-action stage is that local authorities try to render the case academic, by which, as Alice has explained, we mean that they try to effectively alleviate the problem by securing the provision prior to you issuing it. That's not a bad thing if you're representing the claimant. It means that you've got what you want at the outset and you probably don't need to issue proceedings. One word of caution, however, is sense check what the local authority are telling you in their pre-action response. Don't take it at face value. When a local authority says, yes, we've implemented this, we've secured the full-time TA and the 1 hour of speech and language therapy, don't just let them off the hook. Make sure that provision has actually been secured and is in fact being implemented. Your client should be able to tell you that. Because often I've seen cases where the local authority will turn around and say, well, thanks for your letter. Look at all the good work we've done since the letter. This is the name of the teaching assistant that's going to implement your provision. This is the name of the speech and language therapist that's going to start implementing your provision. And you say, thanks very much. You speak to your client. Has it been provided? No, it hasn't. So my general advice tends to be that to avoid litigation entirely, your client needs to be happy that that provision is being implemented. It's not a response for the local authority to just say, yes, we can put the provision in place. The legal duty is to secure the provision, i.e. make sure it's provided. So make sure before you remove the threat of proceedings that the local authority is actually doing what it says it's going to do. That's not to put a downer on things. Usually local authorities do, to be fair to them, but I've seen it where they don't. If you decide you need to issue, then key documents that you need to think about: claim form. So it's on a claim for N461 is the judicial review claim form. Don't use the N461P, that's for the planning court. Get your solicitors, you should be completing the claim form. Sometimes counsel will complete it, but more often than not, it's the solicitors ask counsel or instruct counsel to draft the statement of facts and grounds for you. And I think we've got some SEN advocates on the call as well. So for your benefit, when you issue legal proceedings, which obviously you can't do on your client's behalf, you have to complete the claim form and get a barrister to draft what is usually quite a complicated and lengthy court document outlining what the legal breaches are. Alongside that, you want to be preparing evidence. Now, hopefully, if you follow the steps that I set out earlier, you've got the bare bones of a witness statement together based on what your client's told you. You've probably, hopefully, also got some supporting evidence from the school or the relevant professionals involved that can be exhibited to that statement. And ultimately, you're going to need to be filing the EHC plan to show that there is one, and the local authority is the one who you say should be maintaining it. You'll need the witness statement to address the fact of the breach, i.e. the fact that the provisions not being provided, and then your exhibits should hopefully support that. Not on the slide, but if you're bringing it with the benefit of legal aid, you're going to want to file your Notice 1 form as well. That's effectively the one-page certificate that tells the defendant you are issuing it with the benefit of legal aid. Don't forget to do that. It is an important document. When I'm representing defendants, it's one of the first things that I look for in the bundle, because you then have some idea of what actual risk you are facing as a defendant. I've mentioned about a reply. Something that Alice will come on to shortly is what happens once you've issued your claim. And what should happen is a local authority will file the summary grounds of resistance. As a claimant, you now automatically have a right to reply within 7 days of receiving the grounds of resistance. You don't necessarily need to reply, but often you will want to do so because the local authority will set out its position and its case, and your reply is your opportunity to respond to that. Expedition and interim relief. When you issue a judicial review claim, you can issue it alongside an N463, which is an application for urgent consideration. You don't usually want to do that in a Section 42 claim. Urgent consideration is for cases that are genuinely extremely urgent. So things like people are being deported the next day is one that happens a lot, or things are going to be built the next day that you need to stop. By virtue of the nature of a Section 42 breach, the status quo, even if you're right that a child is not getting provision, will have been in place for some time. It's probably not truly urgent. However, if there is a level of urgency, then what you can do is issue it alongside a request for expedition, or something that I've been doing more and more recently is an application or request for a rolled up hearing. That is where the permission decision and the final hearing take place at the same time. It truncates the process. So you get the claimant documents go in, the defendant documents go in, bundles get prepared, and then you have one hearing that deals with everything in one fell swoop. My general rule, though that's not to say there aren't exceptions to it, is that interim relief often isn't appropriate in a Section 42 case. The High Court generally seeks to avoid issuing interim relief that will alleviate and resolve the entire claim. Realistically, the only interim relief you're going to ask for in a Section 42 claim is for a local authority to secure the provision in the plan. That is ultimately also the relief you want at the end of a final hearing. So often it won't be provided. And the general tendency of the court at the moment is to truncate the process and order a rolled up hearing instead. One point on remedy, obviously you need to ask for it in the claim form. Generally, you're going to be asking for a mandatory order, but don't forget to ask for declaratory relief as well. It's a useful sword of Damocles to dangle over the local authority's head, because even if the case is getting to the point where it's almost, but not entirely rendered academic, under the CPR Part 40, I think it is, you can still ask for a declaration even if you're almost there. So it's worth having that in your back pocket when the local authority says, well, it's about time to withdraw your claim. If it's not totally academic, you can still seek your declaratory relief. Negotiate hard. As I say, that the legal framework is relatively straightforward, and what the local authority has to do to resolve your case is extremely straightforward from a claimant perspective. I think most people representing claimants, although it may not feel this way to a dependent local authority, we do get that there are national shortages of educational psychologists and that local authorities don't have the funding they want. Our point is not that that doesn't exist and doesn't happen. The point is we don't care. In relation to our particular claimant, we have an obligation to them to get the provision that they are assessed as requiring by the tribunal. So be prepared to negotiate hard. Don't just roll over because the local authority says, well, we'll give you half an hour a week of speech and language therapy, and we'll give you half the amount of full-time one-to-one support you're meant to be getting. Just say no. It's not what they have to do to get out of the claim. Lastly, because it's a pain when this happens, but I have seen it, costs. If you are going to settle the claim as a claimant, if you've had to issue, you are entitled to your costs. Usually, some local authorities try to run the argument, well, we'll give you everything you want, but we won't give you your costs, to try to to try to see how you'll behave in that situation. The very, very simple response is costs are irrelevant at this stage. We'll settle the substantive claim, and the admin court, as is set out in the admin court guide, there are a number of mechanisms that the costs can be dealt with separately to the substance of the claim. So whether or not the parties are agreed on the matter of costs, if you are agreed on everything else, the claim can still settle. Insofar as hearing preparation is concerned, I'm not going to go through that because of the time, but in effect, what you need to do is get all the documents together, prepare a bundle, and then ask your barrister to prepare the skeleton argument, the chronology, the statement of issues. They will generally do that anyway. Alice, I'll hand back over to you.
All right, thank you so much. So once you have received your directions from the court, check those orders very carefully, check whether it is a rolled up hearing, when it is, put it in the diary, make sure other members of your team that you've already had those meetings with are aware of the deadlines for the grounds of resistance, aware of the deadlines for witness statements, evidence, and so on. You want to make sure that you are never late for anything, and you want to make sure that you have time within your organisation to check that you are putting in the best possible position on the facts. And the reason for that is because now the claimant gets the chance to reply. So far, I haven't seen local authorities yet try and reply to a reply. We may see that stage, but you're not really meant to. So you have to put in your best possible position in that grounds of resistance. And my advice is to instruct counsel early, ideally actually at the letter before action stage rather than at this stage, but I recognise that it's going to be difficult resourcing wise and so on. But if you can, instruct counsel as early as you can, even if you don't have all the papers, just send those grounds of the grounds of statement of facts and grounds across as soon as you can, particularly if there is a difficult legal issue. Particularly if, for example, there's an issue about, well, actually the child's been off-rolled from a school, what's the responsibility of the school, what's the responsibility of the local authority in those circumstances? If, for example, there's about to be another tribunal decision, that will change the nature of the EHCP. For all of those things, really important to get some legal advice early on, but also because you need usually some practical advice about what information might be missing in order to present that best possible position in your grounds of resistance. So related to that in terms of evidence and related to that witness statement, you may, as I said, have that evidence of what we have done so far to comply, what are we doing, who have we contacted, what are the blocks in the system, if any, what is specific to that child, not as Matt says, the general problems in the system. It has to be, why has it been hard for that child to have that provision implemented for them. There might be one of our really helpful, useful questions in the chat has been about, there might be an example where the young person has themselves had a very difficult experience and has themselves not wanted to engage. So in those circumstances, it's not necessarily going to be characterised as obstruction, but for the local authority is making that provision available technically, but it's being sort of thwarted by the circumstances of that engagement. What I would say for that example, where Section F, for instance, contains weekly CBT and the young person had a negative experience with CAMS, you're thinking outside the box of, well, CBT does not have to be delivered only by CAMS. It could be delivered by somebody else, someone else potentially who's a bit more neurodivergent informed than perhaps a more neurotypical approach. So there are ways around that too. It can be difficult, of course, where an independent practitioner is refused. But again, why is that? What is the problem there? Is there something about the sex of the practitioner that's a problem? Something like that may come up. Chronologies are really important. Usually, as Matt says, the barrister will draft that, but I've seen some really good ones developed by those officers who've had long-term interactions with the family or know really well what's been going on. Often communication logs can be really useful. If, for instance, you as a local authority have been offering an annual review for several years, or for instance, if you've said, we have these experts or these people in place, what's your view? And you've had no reply, or you've just had a sort of unhelpful response. Those sorts of things can be very useful to have as a chronology, demonstrating the efforts that have been taken to put things into place. And that can be useful for you to set the factual chronology yourself, rather than allowing the claimant to sort of run away with the facts. In terms of negotiations, yes, you will see the negotiations in the form that Matt has set out. You may have, for instance, we are very soon able to comply because we're putting in place this training. Just bear with us for 2 weeks. Don't rush into this. Let's stay the proceedings. Is often a useful thing that's raised by local authorities at that stage. If you're close to being able to put things into place, rather than focusing on the proceedings in the High Court, instead looking on the ground at actually making things work in practice. And negotiations, like I said, will often want to be very meaningful. These are parents who are very annoyed about the fact that they've had to fight you for provision that they are entitled to, usually. And so bearing that in mind, some parents will want an apology in those proceedings. Some parents will not care for one. Just bear in mind that there may be wider things that you can deal with outside of the court that may be useful to use and to raise. In terms of further internal action, as I said, you are still running around trying to fix it, if, of course, you are in default. And so is there more work to do? It is always something to be thinking about. And then in terms of the preparation, you may want to ask counsel to speak to each other before the hearing. There may be reasons to do that if settlement is being raised. And there may be an opportunity to mediate. All of those sorts of bits may happen in advance of the hearing. There's going to be a flow of activity, I would suggest, before a hearing arrives. One question was asked about the time frame that we're seeing. So I would say maybe 2 to 6 weeks to get a permission decision after issue, and statement grounds statement grounds are put in. Matthew, I don't know if you're seeing the same sort of time frame from the admin court in terms of their taking how long they take to process Section 42 claims.
I think 2 weeks is a stretch, because obviously you've now got a week to put in a reply. But yeah, certainly the 6 months to 4 to 6 weeks, I would say. Yeah.
And somebody's also asked about the time limit for how things are calculated in terms of judicial review. So usually it's 3 months from the date of the decision, but in any event promptly. Now, often the Section 42 breaches are ongoing, but that doesn't mean sit around. So be mindful. I don't tend to see local authorities taking time limit points on Section 42, because it does seem to be like a live, ongoing decision making that is happening. But hopefully that helps answer that question. Another question has been asked about whether you can bring in the school as a party. There may be circumstances where a school may want to come in as we have seen in some cases involving schools that have been named in EHCPs when they did not want to be. Swarcliffe was a case recently against Wokingham Council, which is a very useful one on being named and not wanting to be there, not wanting to comply. That was more about consulting properly with that school before it being named, but certainly there are examples there of both a local authority and a school being involved as respondents or interested parties as such to claim. And we are also seeing some cases where local authority might actually not contest the claim. They accept they failed to secure provision. And then this is what someone is saying that they've had. We wouldn't necessarily see that sharp end. We see the sharp end. We wouldn't see the circumstances where a local authority has decided to accept it. You may, as a claimant, still want to bind that into a consent order rather than just withdraw. So with a clear action plan for that actually being put into place, so that you can then enforce that agreement between the parties rather than just taking their word for it. Will the video recording be available? I'm not sure. I will find out. I think Miss Watts is typing an answer on that, who's part of our team. Matt, I think it's over to you.
Yeah, so
in terms of questions.
Yeah, I'll wrap up some of the last questions that we've had. Because of time, and there's a couple that are quite case specific, I'm not going to answer those. But we need to deal with some fairly quickly. So one person's asked, how can we find out who the legal aid firms are? If you email me after this, I will tell you. But if you don't want to email me because I'm scary, I'm not. But if you don't want to email me, then look on the government website. That should tell you. But there are kind of 3 or 4 well-known firms that do it. Someone else has asked, can a lay advocate bring a claim on a client's behalf and then help them as a Mackenzie friend in the High Court? I mean, yeah, well, you couldn't sign the claim form, you couldn't issue the claim, you couldn't accept service of proceedings because all of those are formal steps in litigation and you'd be breaching the Legal Services Act if you did. You could help your client complete the claim form, you could tell them how to issue it and they could issue it. When you got to a High Court hearing as a lay advocate, you would need to ask to be a Mackenzie friend. And I suspect that if you were asking to do that, you would probably be refused because you're not going to know what you're doing. In the nicest possible way, you won't. In terms of local authorities who agree to settle a claim, i.e. make it academic, by securing provision, and they say they want to, basically the question is, if we as a local authority have gone to a claimant and said we're going to secure provision, how long should the claimant be allowing us to do it? My general feeling is 2 weeks is fine because there is authority. I can't remember the name of the case. I remember the defendant was Staffordshire Council. There was a case where a particular law firm had engaged at pre-action stage. The local authority had tried to render it academic. They then went off and issued anyway, and they then lost their judicial review claim because they didn't accept that there needed to be some delays in the process. And the High Court, I think, was quite critical of that firm and said, look, you need to accept there will inevitably be delays in the process. So about 2 weeks is probably about right. Let's have a look. Can you say a bit more about tacking on a Section 45 claim? So a Regulation 45 claim, where a local authority ceases to maintain an EHC plan, the actual step to cease it can't be taken until after the outcome of an appeal to the first tier tribunal, if one is issued. In some circumstances, including a case I had quite recently, a local authority made a cessation decision, but just ceased all provision from the date of the decision, despite the fact that my client had issued an appeal to the first tier tribunal. So not only did we argue that that was unlawful, we then also argued the Section 42 breach because they weren't maintaining the plan in the intervening period. Effectually, it's the same factual pattern, but you can argue it under 2 different legal breaches.
There is an interesting question about what happens if an EHCP is updated and the local authority takes out provision that's being argued about, which does happen, particularly because of the fact that, well, of course, an annual review has to happen every 12 months. And we're also seeing difficulties where, say, an emergency review is called and then the local authority decides to amend in those circumstances. So it might be the case that this is being done to usurp either the first tier tribunal process or the judicial review proceedings. And in order to get around that from the local authority side, the important thing is for those regulations that are attached to how you amend an EHC plan are done properly. So it's not done unilaterally without the usual steps that you would take to amend an EHC plan is the main thing. There needs to be a proper review mechanism. There needs to be the 15 days for parents to feed back on that plan, all of those sorts of things. But we are seeing that, and I think there's bound to be some case law imminently on this issue of what happens if there's an EHC plan that then is issued in the middle of these things happening, either first tier tribunal or judicial review proceedings, or both. Because then what does that do for the duty under Section 42 if the issue that the thing that you're trying to enforce then falls away? And I think that we will see some arguments about not acting in good faith or abusive process coming up in those circumstances.
Yeah, Alice, it's 3 minutes past 12. I need to run, so I think we need to wrap up. It's okay. Thanks everyone for coming.
There's a lot of people who've asked some really interesting questions to us. We would be delighted to email us. We've got our email addresses. Our lovely colleague Delphina has just put those into the chat for both of us if you want to ask us any further questions. We've got, as Matt said, another seminar that's coming up, which I think that many of you already signed up to, which is on the 17th of June. That's about section 19. And then 19th of July is about consultations involving special educational needs and disabilities. So if you have any further questions, please do email us. I'm so glad that we had so many people coming along, and thank you so much. And we will speak to you very soon.
Thanks, everyone.
Thank you.